Okay, welcome back from lunch, and I hope you had a nice lunch for those of you here in the room. We left off with limited liability companies, right? So what we were basically saying is that with respect to setting up a business entity, there are four choices: individual proprietor, partnership, corporation, and then within that there's C corporation and S corporation, and then limited liability company. We basically said that an LLC is a little bit different from a corporation in that there's differences in terms of the names of the stockholders, right? They call them members here, and in terms of the principal of the business, the chief operating officer, president under corporation, and managing member under LLC. So an LLC is basically like a club. Now, one of the peculiar things about an LLC is that if you are an owner of an LLC, you can't be an employee on your own payroll. I don't know if I mentioned that or not before, but I'm mentioning it now. So these things kind of get to be kind of weird. We recommend an S Corp, and that way you can actually be on the payroll, and you can actually have your payroll-related taxes as a deduction, which will save you even more money. Okay, so highly recommend an S Corp. If and when you decide to go and get a corporation set up, you can go to that company, myllc.com. In fact, I'll let you in on a little trick. If you go in through my site, which is dotauthority.com, you look for that logo. If you click on that, you'll get a discount. I've prearranged that for you because of our purchasing power. Okay, you can also go to freightbrokertrainingclass.com. And on the left-hand side, it says 20 steps. That's meant for you after this class. Those are the 20 steps to success that you can take, and one of them is setting up a corporation. So you can also click on the link through there. All right? Yes, ma'am. freightbrokertrainingclass.com. Yeah. All right. So let's move on to the next slide here. Now, which way should you go? Well, ultimately, you can talk with an accountant or tax lawyer. If you have any questions in terms of getting that link, just write to us, info@freightbrokertrainingclass.com. If you have specific questions about corporations or LLCs, we would direct you to myllc.com and their toll-free number that's on their website. The next thing you're going to have to do once you have a business entity in place is you've got to get a tax ID number for that business. That's much like a Social Security number that we get as individuals, right? It helps us track our payments into the tax offices, right, IRS and state taxing authorities as individuals. Well, a federal tax ID number is the same kind of thing for a business. It's also known as an employer identification number, and it's used to track tax payments made into the IRS and state taxing authorities from the business. You're going to need that number along with a corporate seal in some states to actually set up a bank account. Sometimes you have to actually have this metal stamp. It's called an embosser, and you actually affix the seal to your bank application. You'll check with your banker as to whether that's needed, and then that makes it official that the corporation is setting up a bank account. All right, you got to have a tax ID number as well. Where can you get a corporate seal made up? Well, you can get a corporate seal and even a do-it-yourself startup kit from easy, right? Easy button, Staples, right? It's funny. Once I ask somebody else to do it, people laugh. When I do it myself, nobody laughs. You wouldn't believe how much money Staples just paid me to do that little commercial, right? Okay, now I'm just kidding. All right, now, if you need to get a tax ID number, you go to the IRS, or you can go through us, info@freightbrokertrainingclass.com, and for a fee, we will get you a tax ID, okay? Now, after that, we need to talk about setting up your payroll, assuming you're going to do what we're recommending, which is start off as an individual, get it running, and then convert over to a corporation, an S Corp. In that case, then you'll get your tax ID number, and then you'll set up your payroll, okay? Now, your best bet when it comes to setting up a payroll is to have a third-party processor handle that aspect of your business for you. Now, unless you have experience working in the payroll department of a big human resources, division of a corporation, this is probably something you don't want to try to tinker with. You're going to have enough to do in terms of doing the operations of freight brokering, right? You're going to be out there trying to find the freight, selling and marketing your service. You're going to find the trucks, set the rates, right? You're going to buy and sell. You're going to negotiate the contracts. You're going to do the billing, do the collections, right? So that's enough for you to do. This is one administrative function that can very easily be passed off to a company that specializes in managing the payrolls for small businesses. So, for instance, Paychex is one such company. We happen to like ADP because of the computer interface that you can use to actually process your payroll. Rather than do it the old-fashioned way and call somebody at Paychex, now Yana in the back runs our payroll by just doing the computer. I don't know what she does, but she does something like that. Okay? Now, if you're interested in talking with ADP, let us know, and we will actually have Larry over at ADP call you, and in that case, he could chat with you about what the costs are associated with setting up your own payroll. Even if you're the only employee, you still should do it this way because it's all legal, number one, and it's easy, number two, right? Now, usually I say be your own boss, cut out the middleman, make more money, all that kind of spiel, right? But this is the one time when I'm going to say it's worth it to have somebody handle this part of your administrative function for you. At the end of the year, they will do the W-2s for yourself and your employee. You don't have to worry about that. By January 31st, it'll be in your hands for mailing to your employees. They do all of the cutting of the checks. All you got to do is give them direct debit access to your checking account that you reserve for payroll, and they'll take whatever money's needed to pay your employees and to pay the taxes that are due to the taxing authorities. So they make it very easy for you. They do the quarterly tax reports that are required, and ultimately you just get to wash your hands of that responsibility. And if the IRS ever comes knocking, you could say, well, I don't know anything about payroll. I hired these guys to do it. Go talk to them, and they'll defend against whatever the IRS position is. All right? So we highly recommend that. info@freightbrokertrainingclass.com is the email address to contact us in the event that you want Larry to give you a call. All right, so once we have this all set up, and that presumes that we also have our freight broker license and bond in our hands, the next thing that we're going to do is figure out what equipment we need in our home office in order to operate. So the minute you have your license and bond in your hand, that's the day that you can start to work. All you really need is a telephone, a fax machine, a computer, reasonably good memory and speed and all that, that has good internet access, broadband, DSL, something to that effect, okay? All right. Those are the four things you need. Now, I don't know if I mentioned this or not in the beginning. We might want to shut that again, I think. Thank you. But I'm from New York over here. Did I say that originally, right? I told you that, right? You know what they say about New Yorkers, right? When you deal with a New Yorker, what you got to do is when you shake their hand and you get your hand back, you got to count your fingers, make sure you still have 5, right? Because you never know what's going to happen when you do business with somebody from New York, right? So I got to warn you that New Yorkers will sometimes kind of fib a little bit here and there, and I just fib to you. There's not 4 things that you need. There's 5 things. In addition to a telephone, fax machine, computer with internet access, you also have to have a good workstation. You got to have a place where you can do business, right? 18 hours a day uninterrupted, right? Nothing wrong with a little humor in the middle of freight broker training class, right? Somebody recently said, so, all right, so how do you print? And I said, well, you just reach back and you activate your printer. That's all. Okay. All right, session 3, licensing, insurance, and bonding. We're going to introduce you to the DOT and our partner Pacific Financial here. All right. Uh-oh. Hold on a second. It's telling me to shut some stuff down here, so let's do that. Oops. Okay. All right, so let's go back to the current slide here. Now, ICC what does ICC stand for? Somebody says it up there. Right, Interstate Commerce Commission. Now, folks, this is the regulatory agency that existed for the most part since 1887 up until 1996. It was originally created to regulate commerce that went from one state to another state, and back in the 1800s, guess how that happened? Wagon or part of wagon, I guess. Railroad, right? They invented the railroad in the 1800s, right? So we had no trucks back then, right? As of the 1930s, that's when they started to regulate trucking companies, okay? So from the 1930s until 1996, all that time, the Interstate Commerce Commission was the agency that regulated trucking. That changed in 96, and for a few years, for about 4 years, the Federal Highway Administration controlled the industry, in addition to a new agency that sprouted up called the Surface Transportation Board. And that was an organization, that is an organization or agency that licenses me as a practitioner. I'm admitted to practice before the STB. As of around 2000 or so, that's when the FMCSA came into being, and in that case, a lot of functions transferred from the Highway Administration over to this new agency. STB still retains some regulatory jurisdiction over carriers insofar as moving companies are concerned, as well as the rail industry as well. Now, a lot of people to this day do not recognize that the ICC is not here anymore. In fact, the old-time truckers, when they call up, they say, boy, can you get me my ICC rights? Right? Stuff like that is what we hear. And we know what that means. They mean they want to get their motor carrier authority. So just because the ICC is gone doesn't mean that you don't still need authority. Of course you do. These days we call it motor carrier authority or interstate authority, and it is now issued by the United States Department of Transportation. Under that, the FMCSA, Federal Motor Carrier Safety Administration. Now, what's the process for you to get a freight broker license from the FMCSA? Well, pretty entailed process here. The first thing that you need to do is you need to make application, and that's done through Federal Form OP1. That can be done electronically or through paper format. Once it is done, your MC number is issued to you. That is not your license. That is evidence that you have a license application in progress, okay? Once that number is issued, it's being given to you for the purpose of you doing two more things under that MC number, and then ultimately a third thing, which is the UCR registration. But for now, once you have your MC number, you have to file evidence of your process agents. Now, folks, don't confuse a process agent with a freight broker agent. They are two different things. We're not talking about sales folks here when we say process agents, and we're also not even talking about the company that you go to process your license application. We're talking about process in the sense of legal process, meaning the service of lawsuit papers. So the idea here is that you're going to be given a federal license. That license will enable you to do business all over the country, and since you can operate in each and every state under that federal license, presuming the load is crossing state lines, in that case, you have to have a legal point of contact in case someone in one of those states wants to sue you. All right, so you have to have a list of agents, 48 continental states. It's got to say who your agent is, what their address is, what their phone number is, and ultimately that gets filed with the government. Rather than you have to try to go out into the world and find 48 people who are going to serve as your agents, we at Excelsior have already put that together for you. That's why people go through companies like ours to get this license process, okay? We make it easy for you. The government doesn't do this for you. We do, okay? So once you go through us, we will do the OP1 filing based on your application questionnaire. We will then contact our third-party process agent company who puts together the list, and they will then file with the government You'll be in compliance with that. The form is called a BOC3. You'll get a copy of it so you know who your agents are. And if ever you need to get served with papers, your agent will then accept the papers and they will forward them on to you at your main office. That's a pretty simple thing. That's all it's for. Okay. The other, of course, big issue is the bond. We've been talking about that all day here. $10,000 for now. We don't know what's going to happen in the future. We'll try to keep it low, $25,000, somewhere around that range, through our lobbying efforts. But regardless, for now it's $10,000. So as you go through the process, you will be required to file a $10,000 bond or the substitution, which is called a trust fund agreement. The problem here with the bond, again, is that the insurance companies do not know the difference usually between exempt and regulated to the degree that our folks do, including the exceptions to the exemptions, which we talked about earlier this morning. All right, so our company, our partner, Pacific Financial, it issues the trust fund agreement. They do know the difference, and they would file a form that's slightly different than the bond. Instead of a BMC 84 bond, it would be a BMC 85 trust fund agreement. They also will do it on the basis of credit. Usually, in order to get the bond from an insurance company, you have to put up the $10,000. So if you don't want to do that, or if you can't do that, you're probably going to have to go with the trust fund agreement option. We highly recommend Pacific Financial because they are the big boys in the industry. They are the top filer. They are something like 6 times their nearest competitor. Most people go through Pacific Financial when it comes to the trust fund agreement. All right, and we will put you in touch with Scott over there, and I'll tell you what the plans are that we've worked out that are special for our clients in just a bit. All right, so remember, the whole idea here is that the bond exists to protect the carrier, to make sure the broker pays the carrier. That's why $10,000 is being put aside. Either you're putting down the money, or you're going to basically ask somebody to put it down for you on the basis of your personal credit rating, your FICO score. They're going to loan you the money, and of course you're going to pay interest for that loan. And we'll look at what the costs are associated with that in a little bit. All right, now the next thing we're going to do is we are going to look at the SAFER system, SAFERSYS.org, because what that does is it enables you to check the license of an entity. It's very important, excuse me, that you know how to do that. So let's go ahead and look at exactly what the process is to check a federal license. So we go to SAFERSYS.org, official government database, and you'll see the FMCSA logo in the upper left-hand corner. After you finish reading through the warnings, which basically say don't mess with us or we'll put you in Leavenworth, Kansas, there's 3 columns. I will ask you to note that the middle column is FMCSA searches. There's 3 links there. The first link is called Company Snapshot, and that enables you as a broker to check the safety record of a motor carrier. So that's good for you, right? You're doing your due diligence. Your job is to make sure that the trucking company is licensed and insured on the one hand and doesn't have a horrendous safety record on the other, okay? You want to hire good, safe carriers. So that's how you do that. You just put in the DOT number of the trucking company, and ultimately the safety record will come out. You can find out how many times the vehicle was stopped for inspection, the driver was stopped for inspection, how many times the company failed that inspection and was put out of service, and you can compare the company's out-of-service rating with the national average. I will tell you that the national average for a vehicle being put out of service when stopped by the DOT is almost 25%. That is pretty high. Now, what that means to you as a member of the public, as a motorist, is on your way home as you're driving on the interstate, if you are surrounded by 4 trucks, 1 in front, 2 alongside each, and 1 in back, statistically speaking, one of them is not safe enough to be on the road. We don't know what the safety problem is. It might be the treading on the tires. It might be no brakes. Let's hope it's not no brakes, and let's hope it's not the truck that's behind you. Okay? That's why when I drive around the country, I avoid driving, if I can, where trucks go. In New York, we have parkways, no trucks allowed, just cars. All right? Drive my kids around, nowhere near trucks. Because unfortunately, the industry statistic is that the carriers just do not properly maintain, inspect, and repair their vehicles to the point where they should. So everything that you do in terms of qualifying the carrier that you're thinking about using should be done in the context of what the national average is. If we could get half of that, that would be pretty good. 12.5% out of service instead of 25, then I would give them a check mark. Hopefully we find 0%, right? But that might not be the case if it's a bigger company. If it's a 50% out of service rating, they had 10 inspections and 5 times they were thrown out of service, are you going to go near them? No, it's double the national average. You can do better than that, right? God forbid that you're in a situation where you're on the witness stand in that lawsuit where you had that load going from Dallas to Houston, and the attorney goes and checks those statistics and finds out that you failed to do your due diligence and you put an unsafe vehicle on the road. But not for the fact that you did that, my client's mommy would still probably be alive today, right? You don't want that to happen. All right, so that's important. Safe stat is usually used by law enforcement. You can go and play with that if you want to, but that's not something that you really need to worry about at this point because they're overhauling that. With the CSA 2010, they're really refining the old system that they used to use, and that has to do with what's called safety evaluation areas. And it's been the subject of a lot of debate because a lot of the data has been proven to be wrong. So they've taken a lot of data offline. So I wouldn't worry about that too much. Really, the safety record in Company Snapshot is what you need. And of course, most importantly, the licensing and insurance tool, which I'm actually going to show you. So we click on the third link, L&I, Licensing and Insurance. That pops up. And the system will prompt you to enter in some information about the entity that you want to check out. Now, you have the option of either entering the carrier's safety number, US DOT number, and then clicking search, or you can put in the docket number, which is also known as the license number, the MC number, for either the motor carrier or the freight broker that you want to check out, or freight forwarder for that matter. You would click the drop-down box and FF would come up. MX means Mexican-based carrier, so you would see this, okay? But what we're going to do here is we're going to search on the basis of, excuse me, a combination of the legal name of the entity and the state where they are based. So let's say that I know that the name starts with the phrase 50 states. I can't remember the full exact legal name, but that's close enough. And I know they're based in Florida. So I click on search, trying to find this company. Lo and behold, on the summary page here, I get 2 hits. There's 2 such companies. One is called 50statesmoving.com, and the other one is 50 States Transport. Now, when you look at this screen, what do you notice that one of the companies has that the other does not? DOT number, right. Top one does not have a DOT number. Now, I just finished telling you who gets a DOT number and who doesn't, right? We said carriers get DOT numbers, but brokers do not. So the one without a DOT number then is probably a broker, okay? Now, you also will see a key word in the legal name of that top entity. Nope. Moving. What is the household good? Oh, I gave it away. What is the commodity is what I was trying to say, associated with moving, and of course it's household goods, right? So remember, every time you see the word moving, you should ask yourself, I wonder if this has something to do with household goods. So that's the thought that we have going into the record. We're gonna click on HTML under View Details. And here comes the full record for this entity. Now, at the top, it says motor carrier details. Do not be fooled by that heading. What that probably should say is something more generic like licensee details, because what follows is not necessarily the record of a motor carrier. It might be a broker or a freight forwarder. So that's kind of a programming mistake. And in about 3 months, when Obama makes me the head of the FMCSA, I'll get that fixed, but in the meantime, we're kind of stuck with that. All right, there's 4 basic parts to one of these records. All right. The first is the generic information here. So basically the numbers, if applicable, right, like DOT, MC, and the legal name, the address, the phone number, everything in this area here is all part 1. Part 2 is essentially this section right here. It has to do with authority type and authority status and whether or not an application is in progress. All right. This is going to be the most important section that you're going to pay attention to. When you are trying to search a record, you're trying to find out whether the entity is licensed or not licensed. The fact that someone can give you an MC number does not mean that they are necessarily actively licensed. They may have never finished the process. They may have gotten licensed but then lost their license. So the one thing that we want to confirm is right now, is that MC number active? Is it okay? So under authority type, there are 3 different types of licenses that are issued. One is called a common carrier. The other is called a contract carrier. And the third is called, of course, a broker. I'll tell you the difference among these in just a moment. Under authority status, for each of these 3, you see the word none all the way down, right? So there is no license in effect in this case. In fact, under the column authority status, there's only 3 words that can ever appear there. One is the word none, which means they don't have a license and they've never had a license. 2 is the word active, which obviously means they're good. And 3 is inactive. Yeah, they used to have a license, but their license was revoked. Why? Probably because they lost their insurance. All right. Sometimes you might see none under authority status. Application pending, yes. That obviously means they're trying to get their license, but it's not done yet. Right? The bun is in the oven, right? Okay. Now, the third has to do with the commodity type. Now, don't worry about the ones on the right here, enterprise and private. That was set up a while back when they thought they were going to put 2 systems into one. They haven't done that yet, so it's really irrelevant. The only 3 that really count right now are these 3 of property, passenger, and household goods. Of course, when we're talking about property, we're talking about trucking, right? General commodities. Property carrier or property broker. When we're talking about passenger, essentially we're talking about carrier of passenger, which is basically bus company, right? Or van service, something to that effect. And then, of course, household goods has to do with the moving and storage industry. We said that before. And lo and behold, on this record, what do we see? We see the word yes under the column for household goods. So all we know at the moment is that this has something to do with household goods. We don't know if it's a broker or a carrier yet because it says none all the way down. So we don't know what they were trying to become. The only way that we can really figure that out is to deduce it. And the way we do that is we look at the insurance type here, okay? And what we're going to do is figure out which of these 3 was applicable with respect to this record. BIPD, you're going to want to write this down. That is essentially bodily injury and property damage protection. Bodily injury and property damage protection. BIPD also stands for Boise, Idaho Police Department, but I don't think you need to know it. All right, so BIPD is basically what we refer to as commercial trucking liability insurance. That's the main insurance policy a trucking company has, right? Bodily injury and property damage. If the truck hits a school bus, God forbid, in that case the damage to the bus is property damage. Damage to the occupants would be, of course, bodily injury. Cargo insurance, that's pretty self-explanatory. Extra insurance policy to protect the shipper's cargo that's on board the truck. And of course, a bond refers to what? Well, we know that. Bond refers to broker. In this instance, under the column insurance required, what was the government looking for? Were they looking for BIPD? Nope, says 0. Cargo? Nope, says no. Bond? Yes. Okay, so that means that this was an application to be a broker of household goods, right? Because brokers get bonds. So it is in fact this one right here that was the one that really mattered. That's the none that's really applicable on this record, okay? Did they get the insurance on file, meaning the bond on file? It says insurance required, yes, but insurance on file, no. So because they did not, that's why it says none when you cross-reference authority status and broker. Had they gotten it on file, then they would be an active broker. If you are a carrier and you're thinking, in this case you would be a moving company, thinking about taking a household goods load from this broker, you would be crazy to do it because they're not licensed and they are not bonded. In the event that they were to collect money from the consumer and you went and did the moving job and you were hoping to get paid, they might not pay you, and then there's no recourse built in because there's no bond. Shame on you for taking a load from an unlicensed broker in that case. All right, any questions about this so far? This is very important for you to understand, know about, and use each and every time you place a load. Now we're going to switch over to the other side. We're going to look at a carrier record from your perspective as a broker. So obviously what I'm trying to say to you is that you're going to have a record like this, and the carrier is going to be checking out your record, making sure you're active, and then vice versa, you're going to check them out. Okay? So what we'll do here is we will back out, and we'll take a look at the second one. Now the second one does have a US DOT number, so they are probably a carrier, right? There's also a code there. Does anybody see the code? 3-digit code, what does it say? OOS. What does OOS stand for? Anybody know? I'll give you a hint. No, close. Out of service. All right, now let me get this straight. You're a freight broker, and you're thinking about hiring a trucking company, and you're about to look at the record of a trucking company. Before you go any further, the first thing you see is that that trucking company has been placed out of service. Do you need to go any further? No. You know you're not going to use them because you're not allowed to use them. They're not allowed to operate. But in case you missed it there, let's go ahead and view the details, HTML. Lo and behold, right dead smack in the center of the screen, in case you missed it, big, bold, blue lettering, this carrier is out of service. Said another way, don't even think about using this carrier, you freight broker, you. All right? That's what the government's message is. Now, most of the time when you get yourself into trouble in this industry, it is an administrative issue. It's a civil matter. It's you did something wrong and there's a penalty in the form of a fine, right? What we call a civil penalty, monetary amount. However, this is serious stuff. Once this carrier has been placed out of service, there is an administrative order in place that says, do not operate. If the carrier disobeys that order, that then goes from being a civil matter to a criminal matter, in which case they can get into a lot of trouble for that, okay? And there could be incarceration time, okay? If they operate, they're breaking the law. If you help them operate, guess what? That's a crime too. Aiding and abetting an unlawful enterprise. In fact, if they operate repeatedly, in that case, that could be determined, if it qualifies as a predicate offense, it could be qualified as a RICO matter, racketeering, scheme to defraud, okay? Stay away from that. RICO is not something you want to mess with, right? Very, very bad stuff. All right, so anytime you see that, you run. Now, I'm going to tell you that there are 3 basic types of out-of-service designations in this industry. The one that you're looking at here has to do with the whole company being shut down. The other 2 are specific out-of-service designations, meaning it has to do with either a particular driver or a particular vehicle. So if we were to go back in time to the year 1994, right, when I stopped you on the New York State Thruway in Binghamton, remember that happened, right? Okay. In that case, then I was doing a road check, had my DOT hat on, I had my gold detective shield that I polish every night before I go to bed, right? Wearing it on my chain, and I'd be pulling all these trucks over into the weigh station. In that case, once I determined that the driver was not keeping a logbook, maybe wasn't qualified to drive for whatever reason, medical, driver license. And sometimes I'd stop a truck and I'd say, let me see your driver license, and they'd show me their driver license, and they would have a driver license, valid driver license. The problem would be that it qualified them to drive a Toyota Camry but not an 80,000-pound semi because it wasn't a CDL. Guess where he was going? He was going to go have lunch in the county jail, okay? Because he's been put out of service at that point, and he's violating a criminal statute. So essentially what we're trying to say here is that driver level out of service would be one type. That's called a federal level 3 DOT inspection. And then if we wanted to have a lot of fun, we'd surpass 2, go right to level 1, and we'd look at not only the driver, not only the compliance for the company with respect to operating authority and permits and all that, but we'd also look at the state of the equipment. We'd have an inspector with us. They'd go underneath the vehicle, check the play of the brakes, and if the actual state of the equipment did not match up to the book, meaning the CVSA, Commercial Motor Vehicle Safety Alliance, out-of-service compliance criteria, in that case, then the vehicle would be placed out of service. Okay? So of the 3 out-of-service types, we have driver out of service, equipment out of service, and the whole darn company is shut down by the United States Department of Transportation. That's what you're looking at up there. That happens when the carrier fails to appear at its initial DOT safety audit, or worse, the company shows up and the government audits them, doesn't like what they see, says you better fix this because we're coming back soon. Government comes back a few months later, it's still a problem, they're thrown out of service. We gave you a warning, 2 strikes and you're out. Okay? All right. Any questions about that so far? You got a lot of making up to do. So you've got to petition the government for another inspection, and you can expect it might take them a year before they do that. Okay? So it's not something that's automatic that you have a right to. Okay? All right. Now, in fact, there's an appeal, and then after that appeal, if you lose that appeal, then you got to wait a long time. Okay. All right. Now, the difference between common carrier and contract carrier. This is a historical difference that dates back to the 1930s when they first started to regulate the trucking industry. And the idea here was between the 1930s and 1980, prior to 1980, it was very difficult to get into the business, okay, during the period of massive economic regulation. So what the government did is it gave out limited licenses to the trucking companies in the industry, kind of like New York City. I don't know if you're familiar with that. The taxi cabs, medallions. You can't just go in and start a taxi business in New York. You have to get a medallion, and there's limited medallions that are given out. So same kind of thing with this industry back then. The only way to really get into the business was either to buy an existing trucking company and its authority, right? You do a transfer application, or you would have to prove that there was extenuating circumstances in the industry. In fact, you'd have to prove that there was a public necessity that warranted the government issuing you a license on top of all the other licenses that it issued. So, in fact, the original license was called a Certificate of Public Convenience and Necessity. And that would be very difficult to prove. You'd have to go to court before an administrative law judge and have to argue your case. You'd have to show something like, of all the trucking companies that are out there, nobody wants to go into New York City because there's too much traffic, tolls, bridges, all that stuff. I'm willing to go service shippers in New York City, therefore you should give me a license. That would be a good justification. All right. Common carriers, therefore, because they were one of a few trucking companies, they had an obligation to serve the public. And the thought was, we better not get any complaints about people who tried to use you and you said no, because if that's the case, maybe we should give your license to somebody else. Take it away from you and give it to somebody who will serve the public. So that essentially was the definition of common carrier. Contract carrier, closed to the public, doing business only with specific shippers with whom they had a long-term ongoing contract. As of 1980, things changed. There was deregulation. Motor Carrier Act of 1980 essentially opened up the industry. Anybody who wanted authority was welcome to have it as long as they followed the law and got insurance. And that's really what authority is all about, regulating insurance for carriers. Both of these types of carriers currently must comply with the government's requirement for BIPD. They must file evidence of trucking liability insurance. Common carrier has the added distinction in terms of having to file cargo insurance for the protection of the public as well. That is the state of affairs right now. I'm trying to give you the full history here of regulation and deregulation. We are now about to go into what I would suggest is the third wave of deregulation. First wave was 1980 when they opened up the market to everybody. Second wave was when they got rid of the ICC. And now the third wave is going to be 2011 when what they're basically doing is they're starting this whole CSA 2010-2011 thing and for safety reasons. And what they're also doing is they're getting rid of the cargo insurance filing. As of June of this year, the FMCSA published a final rule after doing rulemaking, which basically eliminates the requirement that common carriers file their cargo insurance. So that'll happen as of March of next year. So at that point, whereas I'm showing you this screen now in September of 2010, what will probably happen is that under authority type, you will see they will do away with this distinction. There's no reason to have common and contract anymore, so they'll probably just have motor carrier. So you'll probably just see carrier here or broker, and that'll be it. Okay? But for now, until March, common carriers have to file their cargo insurance. Next thing we need to talk about is what are the levels of insurance. And I'm going to suggest that you might want to take some notes on this because this is very important. There's two basic thresholds when it comes to insurance. One is what the government requires. So put down government requirement. And the other is what the industry expects. They are different, and in fact, the industry requires a higher level of insurance than the government does. So if you came to me and you said, James, can you get me all situated and get me my motor carrier authority? I'd say, sure. And if you said, well, how much insurance do I need to get authority? I would say, well, if you're going to transport non-hazardous commodities in vehicles over 10,000 pounds from one state to another, in that case, you're required to have a minimum of $750,000 of trucking liability insurance. Okay? If you get that, you will get authority. However, what you won't get is any loads. And you'd say, why is that? And I'll say, because the industry expectation is higher. The industry requires not $750,000, but $1 million in trucking liability insurance. And if you were going to be a common carrier, I'd say, well, you're going to also have to file evidence of your cargo insurance. How much do I have to have? $5,000 will get you your license, but you won't get any loads unless you have $100,000 in cargo insurance. All right, so very important. You need to know government requirement, trucking liability $750,000, cargo $5,000, but the industry expects $1 million in liability for trucking and $100,000 for cargo. Now, the amount of cargo insurance is really subject to change depending on the nature of the commodity that's actually being hauled. $100,000 for cargo is kind of like general commodities. What if we are in the auto transport business? What if we're going to operate a car carrier, right? In that case, we have to recognize that it's possible that we might have 9 Mercedes-Benzes on the rack, in which case is $100,000 going to cover a total loss of 9 Mercedes-Benzes? Absolutely not. So in that case, perhaps the shipper will dictate a $1 million policy, maybe even more, depending on what the value of the product actually is. All right, so that's subject to change. Also, you need to know that with respect to hazardous commodities, if you were going to tinker with that as a carrier, in that case, you would need to have either a $1 million policy or a $5 million policy, depending on the nature of the hazmat involved. There are 2 levels of hazmat, low level and high level. Low level, you're required to have $1 million insurance by the government, and the industry goes along with that as well. High level, $5 million. Same thing, industry expects that as well. An example of low level, turpentine, paint thinner, something like that. What about high level? Explosives, dynamite, something toxic. In that case, that would be $5 million. All right, any questions? All righty then. Now, when we're looking at this record, excuse me, let's pretend that the safety-related problem wasn't there. Could we hire these people? No, because we see the word inactive. Inactive means, oh yeah, they had their license once, but it was taken away. Why would that be the case? Well, they were required as a common carrier to have trucking liability and cargo insurance on file. It doesn't tell you the amount here, but it's $5,000 for cargo. Did they get it on file? Well, originally they did, but then it was canceled, in which case currently there is no insurance on file, and that's why it says inactive. You're not going to do business with anyone unless you see the word active on their record if it's interstate transportation. All right. Now, getting back to our presentation here. Dual authority. Now, folks, this basically has to do with holding 2 licenses under one MC number. Now, you can have 2 broker licenses under one MC number, household goods and property. That's fine. One bond covers both of them. You can have 2 carrier licenses under one MC number. You can be a common carrier of property and a common carrier of household goods. Trucking company open to the public. Moving company open to the public. Not a problem. What you can't do is mix and match in terms of having both a broker license and a carrier authority under one MC number. If you do that, the government will let you file for it, which in my opinion they're doing you a disservice, but your insurance company will refuse to file your insurance. Or if they have filed, they will threaten to cancel. They do not want you to broker out freight under the same MC number under which you operate as a carrier because they feel that extends their risk exposure beyond your operations. They feel that what that does is makes them liable for all the loads that you're brokering out to other carriers. And they say, oh, no, 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 no. That's the other carrier's responsibility to insure those loads, not yours, and you should not extend our risk in that manner. So what they'll do is they'll cancel your insurance or they'll threaten to do so. It's an insurance dilemma. You might as well separate them from the onset to save yourself a lot of time and money. Now, what are your options in terms of making the separation if you're going to do both businesses? Well, option number 1 is 2 separate legal entities. Option number 2 is you could do one legal entity and add another name to your corporation, doing business as name. But I don't even want to talk about option number 2 because it's not a smart idea. If you're going to have 2 separate business activities, they should be totally separate, not only MC number, but legal entities should be different as well, because think about it. If you're going from New York to California and you wind up in the Pocono Mountains and you wind up hitting a school bus filled with kids, you're done. Your whole business is over. You have $1 million policy. It's not going to cover 45 kids being injured in that accident. Okay? So in other words, your company is going to go under. You're going to go bankrupt. And the question is, if you're operating a brokerage in addition to the carrier business, do you want to pull that down with you? Or would it be better if that was safe and secure in another legal entity name, in which case the trucking company folds, but you still operate your brokerage, right? So the old adage that you've all heard many times, I'm sure, feels like it's appropriate here. Don't put all your eggs in one basket. Yes, sir.
So long as you say we got XYZ trucking company, and you want to start an XYZ brokerage. As long as they got two different MC numbers, is good. What about the title, the legal name itself?
Yeah, what we're saying here, the question is, does the legal name have to be different, basically? And the answer is, yeah, that's exactly what we're talking about. So what you can do here, instead of doing ABC versus XYZ, you can keep one brand like XYZ, and you could say XYZ Transportation Inc. is my trucking company, one legal entity, and then keep the look and feel of XYZ, XYZ Logistics Inc., right? And so anytime the phone rings, all you got to do is say XYZ, right? And you go either way, right? Okay. So yeah, you would keep it as one brand, but technically two distinct legal entities, okay? All right, so you also need to know that you have to have separate books, and I think I said that earlier. So if you have to have separate books, you got to have separate MC numbers, might as well have separate legal entities to protect yourself in terms of your high-risk business going under. All right. Okay. Now, bonds versus trust funds. Real quick, I'm going to go through the 4 plans that Pacific Financial offers and how they're different from the standard surety bond. Again, usually these people in the bonding companies don't know the difference between exempt and regulated, exempt and exceptions, and they just rubber stamp the claims, which is not good for you if they're paying out your money, and that's usually the case. They want you to use your money as collateral for the $10,000 bond. All right? What do they care if they pay out your money? However, it's different when it comes to the trust fund that's offered by our partner, Pacific Financial. By the way, it can take up to 6 months after you close your business for your bonding company to give you your money back. So here you are, you say, I'm done, cancel my bond. You have $10,000 that you put up. You're waiting to get your money back. You're waiting. 6 months go by. They're still not giving you your money until the end of the 6-month period because they want to make sure there's no last-minute claims that come in. They're giving the people an exorbitant amount of time to file those claims, 6 months. Not the case when it comes to the trust fund agreement. Once you shut down, they give them 30 to 60 days, and that's it. If they haven't filed their claim, too bad. They'll have to sue you. You get your money back if you put your money down to begin with. Perhaps you did it on the basis of your credit rating. That's what's nice about the trust fund agreement. They also will back you up. Rather than just rubber stamp a claim and pay it, they will say, we think we should pay it. Do you have any bona fide reason as to why the claim should not be paid? If you do, they will defend your position and actually deny the claim. Now, Pacific has 4 different types of programs, cash and credit-based, or a combination thereof. Plan number 1, cash plan. You're going to take $10,000 out of your bank account, and you're going to hand it over to Pacific Financial. They will hold that money in trust. That will serve as the collateral for your trust fund agreement. Anytime they need to pay a claim, they take it out of that $10,000. You then have to replenish your $10,000, or you have to replenish the fund to get it back up to $10,000. Otherwise, they cancel your bond and they cancel your license. The cost to you to do this is a one-time fee. It's $550. You don't pay any more money. That's the good news. What's happening here is the $10,000 is going to be put in an interest-bearing account, and it's going to earn money, right? Your money is going to work for you. And rather than you pay the annual fee, they just take the interest, they call it a wash, and they only charge you for the fee one time, okay? That's the good news. The bad news is that Pacific, I have to tell you, is not a bank. They are a duly licensed financial institution, but your money is not insured as if it were in an actual bank. They're not FDIC insured. Okay. Now, I don't have any belief that anything's going to happen to Pacific anytime soon, right? It looks like everything's financially stable there. We've been doing business with them for about 8 years now. We've never had any problems. But I don't want to steer you in one direction without you understanding fully the ramifications of your choice, right? So you can either choose to avoid the annual fee and let them hold on to your money in the expectation you're going to get back, or you can leave your money in your bank in a CD locked away, and your bank will become a co-trustee with Pacific for the money and with respect to the claims. So in other words, your bank holds the money, and Pacific makes claims decisions and pays out the money as needed. Your bank files an irrevocable letter of credit with Pacific, which gives them the right, which gives Pacific the right then to draw down on the money as needed to pay the claims. All right. In this case, your bank is going to pay you, right, interest on the CD, but you're going to have to take that money, probably a little bit more, and pay $550 every year to Pacific for the cost of administering your claims, all right, for being in place. So that's your choice. When it comes to not having the money or not wanting to put up the money, Plan 3 is a good option. You don't have to worry about the $10,000. All you got to do is have really good credit. And if that's the case, personal credit rating is high, then Pacific will say, all right, what we're going to do with you is we're going to charge you $550 administrative fee, and you're going to be loaned the $10,000. We're going to basically loan you the money, and you're going to pay us interest on the loan. So you'll pay us $400 per year on top of your $550, so $950 total per year, but you don't have to put down any money, and you're in business. Right? A lot of people like that particular plan because it's not a matter of coming up with $10,000 all at once. $400, yeah. You're going to pay $400 for the year, $400 interest. So it's 4 points on the $10,000. Okay? Per year for as long as you want to be in that plan. Now, maybe you just do that for the first year, and then you pull out of that plan, and then you go into Plan 2, where you've made money, and of your profit, you now use that to collateralize your financial instrument, and you do the CD deal, right? Which is what I would do, right? But this can get you started. That's good, right? It's worth $400 to go into business, right? Okay. If your credit score is kind of just under their threshold, what they may do is they may still invite you to work with them, but what they might do is tell you, all right, we're not going to indefinitely loan you the money, right? We're a little worried about your credit rating. So what we'll do is we'll advance you the money, which means that they're going to put up the money for now, but you're going to pay them back each month over time, okay? So they will charge you the $550 administrative fee plus the $400 interest for the year. And in addition to that, in addition to fees paid, fees that you'll never see again, you will start to put down your money, which inevitably you will get back at the end of your business. So what they'll probably do is say, we want a down payment towards your trust of $500, and then every month we need a monthly payment from you until you build up to $10,000. Okay? The typical monthly payment is $500. Being the nice guy that I am, I have negotiated a special deal for my clients. Rather than you have to pay $500 a month as you're starting off toward the end of this recession, in that case, you pay half of that. You pay $250 a month. And it'll take you a little bit more time to pay it off, but it'll be easier on you to make those payments each month. Okay? So you got to tell Scott, you're one of my clients, James Lamb, and in that case, then he'll say, oh, okay, yeah, I got that special deal with James. I won't charge you $500 a month. I'll charge you $250. Right? And it's not charging in the sense it's fees paid. It's your money just going into your trust. Yes, ma'am.
Trust fund 3 or whatever the case may be, and or say trust fund 1 when you put up to 10,000, and then you go back and you want to change that, maybe put it in the bank, say trust plan 2. Is there, from year to year, is there a fee associated with that if you wanted to switch it?
I don't believe so. You'd have to ask them that, but I don't believe they're charging that. No, I've never heard of that. No one's ever asked that, actually. I I've done this 250 times. Nobody's ever asked that. It's a good question. Yeah, I don't know the answer to that.
I mean, for instance, if you thought, you have the money, you put it up, and then you decide, well, you want to earn money on your money versus leaving it in that
Right.
risky investment.
Yeah.
And switch it after a year or so.
Yeah. I switched once on my broker license, and they didn't charge me, but it might be because I have a special relationship where I'm set in the business. So I don't know the answer for the general public as to what they would do. But you could talk to Scott. If they do, it can't be a huge fee because at this point they're only charging you $550 for a whole year. So I wouldn't expect any surprises like that. And if you do get an answer that seems kind of weird, let me know, and I'll talk to them about that. Right? Okay. So Plan 4 gives you the ability to get into business and pay them back over time. Okay. All right. Now, if you don't have the money or you can't get through based on your credit, there are other high-risk bonding companies that are out there. And if you're in that situation, try Pacific first. Talk to Scott. I'll tell you, they were a lot more picky back in the day of good economic times than they are now. They've kind of gotten a little bit more liberal when it comes to making these types of decisions. So I haven't had anybody denied in I don't know how long, a long time. So I'm sure they'll work with you. And if you have a problem, though, then we'll refer you to another company. Yes? They don't tell you what the threshold is. It's kind of like a proprietary thing. A few years back, we were kind of able to deduce that it was somewhere in the area of about 730. But that was like in 2005, 2006. I doubt that it's that high at this point. So I wouldn't worry about it. I would basically just let him run your credit and see what he says, which plan he can put you in. Hold on with me one sec. All righty. Oops. Okay. All right. Now, I need to tell you about insurance. Now, insurance is different from bonding, of course. Think back to the beginning of today's program where I told you that there is no statutory liability on brokers, right? So we said that brokers are not required by law to have cargo insurance in any way, but the shipper may demand it as a condition for doing business. And we said that that was essentially contractual liability, and in order to cover your liability, you might have to go out and find contingent cargo insurance, okay? I got a lot to say about this. Number one, you need to recognize that there are two different types of contingent cargo liability policies. There's what's called follow-through and non-follow, okay? Follow-through is essentially an insurance policy for a freight broker that mimics or follows the same terms on the policy that the carrier that they employ has. So in other words, the motor carrier purchases cargo insurance. Whenever you buy insurance in general, as you probably know, there's usually a document that clarifies the exclusions, right? Which basically is their get out of claims free card built into the policy. The underwriter writes and says, okay, you're insured as long as one of the following 7,326 things never happen. Right? So there's these exemptions. I'm being facetious, but you get the idea. Usually on a cargo insurance policy, what happens is the insurance broker says, here's the policy and here's the premium that you're going to have to pay, trucking company. And the trucking company says, oh, no, that's too high. I'm going to have to go find another broker to find me a cheaper policy. So the broker says, all right, well, wait a minute, I have an idea. What we'll do is we'll increase the exclusions and thereby decrease the cost of the premium. So you will still be able to get your insurance. We'll do the filing with the government, which is what you need. You'll be able to show the shippers that you have insurance and brokers, but it's really not worth that much because there's too many exclusions. Okay? And they'll be like, yeah, all right, whatever. We just want to keep the cost low. Okay? very often the typical exclusion that appears in a cargo insurance policy is the cargo is covered as long as the driver does not walk away from the vehicle. Now think about it this way. If something's going to happen, is it going to happen when the driver's there or when the driver's not there? It's going to be happening when the driver's in the restroom right at the truck stop. So if between the 7 minutes that it takes to go inside, maybe he gets a cup of coffee as well, and come back, if something happened during that 7-minute period, no insurance. You shouldn't have left it unattended. It's a unattended clause in the policy. So if that's the policy on the trucking company's cargo insurance certificate, then if you have follow-through contingent cargo insurance, it means that your insurance doesn't kick in either because it follows the same terms. So if the shipper thought, oh, well, I'll try the broker's insurance, not going to work, right? And that keeps the premium down for the broker, right? Non-follow-through means, no, we're going to set our own rules, right? So the best for you to get, if you're going to do this, would be to get non-follow-through contingent cargo insurance. You're not handcuffed to the terms of the motor carrier's cargo insurance policy. Now, we're also going to suggest that there is a major problem with contingency cargo offered by many companies in and of itself. I don't know if you know that insurance companies are rated in this country based on an ABC scale, right? You probably have seen those commercials within the last 6 months by Allstate about how they do the right thing, right? You're in good hands and we do the right thing. They're trying to highlight the fact that they're rated as an A insurance company. A pays their claims. They don't play little games. They don't try to weasel out of the claims. C, not so much. C will play games with you. So obviously an A insurance company is the way to go. Now, the same thing happens here with a lot of these companies that offer this contingent cargo insurance, and what they do is something very sneaky, and I'll tell you what that is in just a moment. The basic problem with cargo insurance, contingent cargo insurance, is that number one, you're not required to get it. Number two, you're kind of being forced into getting it, in which case you got to pay more money. You're already paying for a bond, now you got to pay for insurance as well. You're not supposed to have to pay for insurance. Number three is when you get the insurance, it's like opening up a can of worms. So that if you took on the liability, which you didn't have to take on, in that case, if something happens, then you could be sued for the amount of your liability. Whereas if you rested with the law and you said, I'm not going to play this game, if they wanted to come after you, in that case, you'd say, oh, no, I'm not liable. Go look at the law. I didn't do anything negligent, so I'm not liable. Can't impose liability on me either. Of course, the catch-22 is if you don't agree to the terms, you're not going to get the business to begin with, right? So that's the predicament that you're in. So a lot of people will just go and get the insurance. You have a choice that you have to make. Either you do what you're being told to do by the shipper, you walk away from the business. Doesn't make sense to walk away, right? So people wind up doing what they're told. The biggest problem is there's what's called the possession trap. Now, I didn't make this up. This is something that comes from a very well-renowned lawyer in the industry, Bill Augello. Well, Mr. Augello was a lawyer in the transportation field for 50 years. Spent his whole life doing this. He wrote a book at the end. He just passed away about 3 years ago. But before he did, he published a book. The name of that book is called Transportation, Logistics, and the Law. Transportation, Logistics, and the Law by William or Bill Augello. And that's spelled A-U-G-E-L-L-O, just like the Jell-O pudding, right? Augello. Okay. Now, what he did is he basically warned new attorneys, because he was a professor of transportation law, so he taught new attorneys. He said, now, watch out for this. Make sure you don't let your clients fall into the possession trap. And the way this works is the insurance company will write the policy, and there's that famous exclusionary document, and they'll say that you're insured as a broker, as long as you take possession of the property. Anybody have a problem with that?
Yep.
What's the problem? Brokers never take possession of the property. So you see how it's built in so that it's no win for you and win-win for them, right? So in other words, they sell you the policy, you pay them money, they wait and wait and wait, and they collect the money, collect, and then one day there's a really bad incident. It's a $100,000 claim. And in that case, they're about to pay the claim out, and what they do is they say to you, now let me just ask you one last question, James. You did take possession of the property, right? And they know what you're going to say. Well, no, I'm a freight broker. I never take possession of the property. Well, gosh darn it, James, we were all ready to write that $99,000 check out to you, $100,000 less $1,000 deductible. But unfortunately, the underwriter put in here that you got to take possession. Now, you want to see a New Yorker come out in me? Forget about it. Let me get this straight. You're telling me you sold me insurance that I could never actually file a claim on? That's not called insurance. That's called fraud, in my opinion. All right? And, of course, what they'll do is they'll backpedal and they'll say, oh, geez, I guess we made a mistake. We thought you were a forwarder. And that's when you take possession, right? Legal possession. So, oh, you're a broker? Oh, well, then, we made a mistake. But don't worry, James. We're going to make good on it. That premium that we stole from you, basically, we're going to give it back. We'll make it good. We'll make you whole. Now, here you are expecting a $100,000 payment, maybe $99,000, and you're going to get $3,472.56 back. What's the point of that? So, in other words, you're going to unsell me insurance at the very moment that I now need insurance. Yeah. You're going to wind up in court, and you're going to wind up suing them. Your shipper is going to wind up suing you because you led them to believe that you had insurance when in fact you didn't, and it's going to be an absolute nightmare and mess. Instead of spending time selling and building up your brokerage, you're going to spend all your time talking to your attorney about how you got to appear in court on the defense and appear in court on this day on the offense, right? Absolute mess. My suggestion is to try to avoid this entirely if you can. Now, how do you do that? Well, in the event that your shipper requests evidence of cargo insurance from you, there's two different ways for you to interpret that. There's way number one and way number two. Way number one is what they're saying to you is prove to us that the load is insured through you. Think about that. Prove to us that the load is insured through you, broker. That's a little bit different than number two, which is prove to us that you have a secondary backup supplemental policy in your name in place. Now, they may sound like the same thing, but there's an important distinction there. Through you doesn't mean it's in your name. It just means that you're going to be listed on an insurance policy somewhere, okay? So what I'd recommend is that when you get the request, you choose which way that you want to interpret that, and you say, oh, you want me to prove to you that the load is insured through me? Yeah, sure, we can do that. Now, keep in mind that when the shipper is dealing with you, the shipper has a checklist. Just like you are going to have a checklist as the broker when it comes to hiring a carrier, right? Got to make sure they're licensed. Got to make sure they have motor carrier authority. Not just any old authority, but the right type, inter versus intra. Got to make sure they have a good safety record. Got to make sure they're insured, right? Check, 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 check. The shipper has the same type of checklist. They got to be a licensed broker? Check. They got to have a bond? Check. We need to make sure there's an insurance certificate on file for them. That's the box that we're looking for them to check next. What you do here, and what's common practice, is you go and you contact your trucking company that you're about to place the shipper's cargo with, and you say, okay, shipper wants to have evidence of your insurance. So what I want you to do is call up your insurance company and put me, my freight brokerage, under your insurance as what's called an additional insured, okay? Additional insured. So the broker gets listed on the motor carrier's cargo insurance as additional insured. What that does is, number one, enables you to get the certificate of insurance that's got your name on it, right, from the insurance company. They'll fax it to you directly. It gets you put on the mailing list, so anytime there's a change to the policy, like a cancellation, you'll get notified. And it's going to enable you to essentially satisfy the request of the shipper as you understand it, okay? So here you get this document from the insurance company. You're going to fax it to your shipper. It's got your name on it as additional insured. They check the box. 9 times out of 10, they check the box. Yes, ma'am?
How often does that really take place where they actually, where you, a carrier, or shipper, shall I say, will put you, a carrier will put you on their insurance?
The question is, how commonplace is it for this to happen, basically? And the answer is it's very commonplace. It is standard operating procedure. In fact, yeah, a lot of people, for those of you who are carriers, you know this because you're asked this from your broker all the time. Let me say, what's nice about it also is that it enables you to file a claim then directly with the insurance company rather than beg the motor carrier to do it for you. So you can give better, more timely customer service to your shipper. You want to file a claim? Sure, I'll take care of it. Boom, you do it. Not only is it okay for you to do this, not only is it reasonable for you to do this, but it's expected. And what that means is that you have to do it for another reason, not only for the legal protection reasons and to satisfy your client, but you need to do it for a power dynamic reason, meaning the carrier is waiting for you to do it. If you don't do it, he's going to wonder why. He's going to say, now let me get this straight. Every other broker that I've ever done business with has always asked me to do it. And that's probably the case, except for this one. Why didn't this woman ask me? What's different about her? And then they're going to look at your paperwork. And you know what they're going to see? The first thing that they're going to see is your MC number. Now, your MC number, if you apply now, is going to start with the digit 7. The first digit in your MC number tells the whole industry whether you're new or old. All right? Everybody knows it. Other brokers, shippers, carriers, everybody knows this. So if you think you're going to be slick and you're going to start off on the first day and someone's going to say, so how long have you been a broker? You can't be truthful and say, well, today's my first day and this is my first load. Right? You can't do that. So you say, oh, well, I'll embellish a little bit. Oh, yeah, I've been a broker for what? Got to be about 4 or 5 years now. Not when your MC number starts with a 7. In essence, you got your MC number, relatively speaking, last Tuesday. All right? Everybody knows it, okay? So, you know, don't fall into that trap. So once they see that, they'll say, oh, MC number starts with a 7. That's why she didn't ask. You know why? Because she's so new, she doesn't know yet that she's supposed to ask. A lot of people don't go through training. They don't get told. So you go stumble around and figure it out yourself, right? 6th load, you're like, oh, I guess I'm supposed to do this, right? So what that then does is it sends out bad signals, right? Unprofessional, but more along the lines of vulnerable. It's like blood in the water. What comes when there's blood in the water? Out of nowhere? The sharks. So they will eat you alive. They'll say, well, if she doesn't know about this, if she doesn't know much about rate negotiations yet, I'll bet you I can walk all over her. What's the name of her company again? Doormat Logistics, right? There you go. Okay, so good question. Yes, it's commonplace and you should always do it. All right, so you try that. 9 times out of 10, that'll work. That'll satisfy the shipper. Obviously, 10% of the time, there's 2 boxes that the shipper has. They were expecting that one for confirmation of the carrier's insurance that you're on, but now they want your insurance, in which case now you're back to that dilemma, the catch-22. What do I do? Do I get the insurance? If you are going to get the insurance, non-follow through and have an attorney look at the terms to make sure they're not playing that possession trap game, okay? If you don't want to mess with that, you can say, no, I'm not going to do that, and either walk away, which doesn't make much sense, or you could pull a little rabbit out of your hat. And what I mean by that is what you'll do is you'll be wearing your broker hat, talking to your prospective shipper, Sony Electronics, and you'll say, I'll tell you what, Sony, how about this? How about we take off our broker hat and we reach down here, we pull out our other third-party intermediary hat, namely our freight forwarder license. Freight forwarders take legal possession of the property by virtue of the law, the bill of lading that they issue. Remember the difference? Brokers issue an invoice. Freight forwarders issue a bill of lading. That sets up the terms and conditions and makes them legally liable for the actual cargo. So in that case, to cover their actual legal liability, the government, at least for now, requires that the forwarder file evidence of their cargo insurance. That's going to change in March as well. All right? In which case, you want to be insured? I'll tell you what, we won't play this little game that you and I both can get burned on by this insurance company. Now, forget that. We'll do it as a freight forwarder. We will knowingly take legal possession of your property per the bill of lading. Here's evidence of our freight forwarder authority, which means we have cargo insurance on file with the FMCSA. Otherwise, we wouldn't have been issued our authority. And that means that if something happens, you're insured and I'm insured. Right? No games. And when you go to make the claim with your insurance claims adjuster, they'll ask you, so, did you take possession of that load? And you'll say, well, as a matter of fact, Mr. Claims Adjuster, yes, I did. Here's evidence. Here's the bill of lading. Claim will be paid. They can't weasel out of the claim. Okay? That's the way you beat the insurance companies at their own little game. You like apples? How about them apples? All right. All right, so now am I recommending that everybody run out and get the freight forwarder license the same time as the broker license? No, try the broker license first. Start to go through the process, do the additional insured document. If you start to see that too many times you lose out because you didn't actually have the contingency cargo insurance, you either got to go and buy it or then it's time to become a freight forwarder. Okay.
The difference in the cost of the freight forwarder versus just the broker's license.
Same deal. Same exact thing. Yeah. So get the second license. Right? You were going to buy the insurance anyway, so why not have another license associated with real insurance? Right? Make sense? Yeah. Now, in terms of going a little bit further on insurance, general liability insurance is something that's optional when you're working from home. If you expand out of the home and into a commercial office setting, then you got to get this. This is a general liability umbrella type policy, $1 million coverage as usual. If you're going to rent office space, they're going to want to see you have evidence of this. They'll ask for the certificate of insurance. And it's also there to protect you in case there's fire, theft, damage, or somebody comes in and slips and falls. Right? It's rented space. You got to insure that rented space. In the meantime, if you're working from home, your homeowner's insurance or apartment renter's insurance should cover any theft, damage, fire incidents. But they won't cover flood. You got to have a separate flood insurance policy because that's an exclusion on your typical homeowner's insurance. Gotta love insurance companies. All right, in the meantime, there's also standard errors and omissions coverage, what we call E&O. Good idea to get this, okay? E&O basically means you are covered in the event that you make a mistake. What type of a mistake might a freight broker make when he first starts off? Well, I don't know. Maybe it's your first day as a broker, and there you are, arranging for the transportation of milk in a standard van. Oops. Is that a cargo liability issue? Not really. It's about negligence. It's about a mistake. Okay, moving right along. Now I'm going to skip over some of the stuff because this is us trying to sell you something here, right? So very quickly, you have the ability to get a freight broker license yourself through a permit consultant or through a practitioner. By now you should know that I am a practitioner, duly licensed certified expert by US DOT, admitted to practice before the STB. It's similar to being a state licensed attorney, except my area of practice is limited to the administrative agency that has admitted me. Okay, so I'm not a lawyer, but I'm treated as if I'm a lawyer within the DOT. All right, licensed practitioner. So it's kind of like in the tax world, when it comes time to doing your taxes, you can either do it yourself, you pull out TurboTax, or you go to H&R Block, a tax preparer, or you go one step up for paid professional to a CPA, Certified Public Accountant. Nobody knows the tax world better than a CPA. They will maximize your deductions and allow you to avoid certain taxes. Not evade, but avoid. That's legal. Right? A tax preparer will probably help you get through the process a little better than you would do on your own, but they may not maximize the amount of your return. All right, so same kind of deal. Practitioner is a higher level than a permit consultant. The fee for you to get a freight broker license through us is $750. That includes your MC number, the government filing fee that's required, our fee, and the fee to put together those agents, 48 states. Okay, so everything's all included. Only things that it does not include is the bond and your UCR state registration. If you want to go through us for UCR, I think it's $187 for 2010, and then it'll be due again for next year soon for 2011, same price. All right, that's a combination of our fee and the state fee as well. All right, so keep in mind that that's an option for you. And of course, you know the bond fees. We just finished talking about them, and you have them all written down on your form there. Okay. Yes. Yeah, it's calendar year. Yeah, it doesn't go for a 12-month period. So if you're going to do business at all in the year 2010, you got to pay the 2010 fee. It's not prorated, right? So in fact, we're about to start the process of doing our mailing now to our clients, saying, hey, it's time to start collecting for 2011. October is when they open up, and some of the clients just got their DOT number like the week before. Well, I just paid this. Yeah, you paid for 2010. Now it's time for 2011. Welcome to the world of regulated transportation. All right. All right, so you have a choice basically of doing it yourself, going through a permit consultant, or going through us. And by the way, there's some of these permit consultants as well as lawyers who actually will charge you $1,000 to get this done. We've seen the competition charging that amount. So you would be overpaying if you did that. All right, now for you folks, because you're all my good friends now, what we've done is we have a special offer that expires midnight tonight. So if you're thinking about doing it, see what kind of salesman I am? You see where I'm going with this, right? Trying to get you to buy today, right? High-pressure sales tactic coming at you, right? No, it's not a high-pressure sales tactic. It's an offer. It's a special offer, right? So if you are interested in doing it today, you can see Yana before we leave here today, and you can pay her. She'll be happy to take your money, either credit card or cash, if you happen to be walking around with $750 in your pocket. Or you can do it after you leave here before midnight. You just fill out the form and fax it in, right, as long as we get it by midnight. Or you can go right on the computer. I'm going to give you a secret code that you're going to use to get this special price, right? You'll save $50 whole dollars. Imagine that. Right? So instead of $750, you will pay $700, right? And here is the special code. Now, I'm recording this webinar, and this offer is only available to you folks in the room. So we're not going to say the actual code out loud. We're going to write it down, and these people can't see that. Of course, if they call me, I'll probably work out something with them anyway, but we won't tell them that right now, right? So the code is this word. Top secret word, discount word is right there, okay? It's only available today, okay? All right, so if you go on the computer before midnight, you type in that special word, that's your coupon code, it'll get you a $700 deal. Today only. All right, isn't that like a really cool way of doing it? Yeah, that's it too. I bet you people are wondering what the word is. I'm not going to tell you today. All righty. Now, that's your deal. Okay? Now, what's the process of moving forward? There's a questionnaire in your red folder. And if you complete that and you give that to us, then we'll go ahead and we'll do the electronic filing for you. OP1 application will be done immediately. In fact, it might even be done before 5 o'clock today if you catch her during the next break if you're really anxious to get going. And in that case, what will happen is your MC number will be issued to you before you leave here today. Right? You'll actually have it. Now, that's not your license. That means you've started the process, and within the next 3 weeks, you can expect to get your license. Once your license application is published, in that case, it'll start what's called a 10-day public notice and comment period. That means that the industry has the right to know about your application, gets put up on the daily register for FMCSA, and they have the right to comment in favor of or in opposition to your application. Why would somebody protest your application? I don't know. It might have something to do with the name that you choose to call your company. Let's say you leave here today and you say, you know what, I'm real excited. I can't wait to do this. I'm going to be a freight broker. I want to be an entrepreneur, be my own boss, make more money, cut out the middleman. I'm not going to work for anybody ever again. I'm going to start my own business. I, too, am going to go to Paris, France, right? You know, in that case, you get on the computer before midnight, and today you put in your code. And in that case, what will happen is you'll actually get your MC number. Let's say you choose the business name CHH Robinson. You say, that's going to be my unique name in the industry. I'm going to call myself CHH Robinson, Freight Brokers. You think there might be a problem with that? For those of you who are aware, there's a big company, publicly owned, called C.H. Robinson. Multi-billion-dollar company, as a matter of fact, huge, and they might have something to say about you starting a new business calling yourself a confusingly similar name. And that's the term that applies to the Lanham Act, which has to do with trademark, and ultimately they will basically protest you first and say, last chance, either change your name or else, and if you don't, then they'll sue you for trademark infringement. In which case, you'll probably do the easy thing, and what will you do? Change your name.
How, if they were to protest the name, how long is that period of time before you actually award your license? I know it's 3 to 4 weeks already, so if they protested.
Well, that puts a freeze on everything then. If there's an actual protest, now their attorney has to appear at a hearing, you have to appear at a hearing, and you've got to defend against their protest. You have to, it's almost like an actual court hearing where there's an order to show cause, right? An order to show cause meaning show the court cause as to why your application should now not be denied, right? Absolutely. So the best thing to do is don't step on anybody's toes. Okay? Use a very unique name and you won't have to deal with that. 10 days later, business days, your license will essentially be ready, assuming you did the other things like get your process agent on file and get your bond on file. Best case scenario, 3 to 4 weeks. Okay? Now there's also a service that we offer. We call it License Watch. That's one of our brands. And License Watch means that we are watching for your license to be issued every day. Right? So it's going to be issued somewhere in between those 3 to 4 weeks. We're not sure exactly what day, but every day we're looking to see if it's there. We have the ability through a third party that we contract with that has a license from the government to go in and retrieve data. They have the ability to send you that document by fax. Our price point for that, for taking care of all the people involved in this, trying to do that for you, it's a $100 fee. So what that means is for an extra $100, you will have an expedite service of receiving your license the same exact day that it's issued. In fact, don't tell anybody, but it usually comes out the day before it's issued, so you're prepared that morning, first thing, you can do your business. Okay? Now, I don't know what you know about government workers, but since I used to be one, I can tell you that it's going to take 3 to 4 weeks for your license to be ready. What that means is it's in the computer system. So here's the day that your license is available. If you don't do the fax, the License Watch service, here's what's going to happen. Eventually, over the next 3 or 4 hours, the government worker will print the document. Then they'll go take a break. Then they'll come back, they'll pick up the document, and they'll fold it, get it ready for mailing. Then they'll go and they'll take another break, their lunch break. Then they'll come back and they'll put the document in the envelope, and they'll put the stamp on it, they'll seal it, and right as they're about to put it in the mailbox, it'll be time to go home. In which case, they'll put it back on their desk and they'll deal with it tomorrow. And then at 10 o'clock tomorrow, when they finally finish their morning newspaper reading, then they'll eventually get it out to you, and then it'll take 3 to 4 days to get it in the mail. So if you want to play that game and wait on the United States government, well, you can do that. Or you can rely on the private sector and just buy the expedite service and have it faxed to you. It does not speed up the issuance of the license, but it does speed up the receipt of the license because you get it by fax. All right, if you want to do it the old-fashioned way and do it through paper application, it's going to take 3 to 4 weeks just for you to get your MZ number. And then it's going to take another 3 to 4 weeks. So usually it's about 4 to 6 weeks, as much as 8 in some instances, to get processed that way. So electronic filing is definitely the way to go. All right, so benefits of going through us: reasonable application fee, $750 for you. For those of you in the room today, you will get $700. You try not to laugh, but I see you smiling back there because it is still funny. I know, right? Quick electronic filing gets you the MC number immediately, and you have a licensed practitioner available to you to represent you before the DOT. So in the event somebody did protest, then I would help you with that. In the meantime, if the government has any questions about your application, maybe they want to talk about your other authority and your bad safety record, instead of them talking to you directly, they're not allowed to once I make my appearance, because you are now represented. Like having an attorney, right? They got to talk to the attorney, not to you directly. And then I would confer with you, and then we'd figure out what we're going to tell them, okay? And of course, we'll tell them the truth, but we'll figure out what our position is. All right. So, last segment here, regulatory facts versus fiction, dispelling industry myths. I can get my broker license in just 30 minutes. True or false? False. It's a 4-week process, 3 to 4 weeks, because of the waiting period. A carrier can broker out loads. True or false? False. A carrier that brokers out has to have a separate broker license. All right, and that's actually a topic for this current Senate legislation. That's actually one of the good things. It clarifies you got to have a broker license. And if you operate illegally, then you're going to be in a lot of trouble. Okay. Now, the next session is on regulations. I'm not going to stand here and read the regulations to you because I don't think that's what you're here for. But what I am going to do is point out a couple, and then you guys can read the rest yourself. I already gave you the gist of the regulations. All right, so what we'll do is we'll start off here with the official definition of broker, because you need to know that. A broker means a person who, for compensation, arranges or offers to arrange the transportation of property by an authorized motor carrier. Note, there are 3 elements. You got to be a person, you got to get paid, and you got to either actually broker a load or hold yourself out to the public as being willing to broker a load. So the warning here is, if you are going to talk to one of my competitors who are going to try to tell you, oh yeah, we'll get you a broker license in 30 minutes, and they give you the MC number and they say, here you go get them. You know that's not a license yet. You haven't gone through the whole process. If somebody checks your MC number, it's going to say authority none, application pending yes. Right? But if you're silly enough to go out into the industry, go onto Google and put an ad up and say, hi everybody, I'm the new freight broker in town, here's my MC number, come pay me. Oh boy, you just broke the law, didn't you? Because you held yourself out to the public, implied for compensation, and you're a person. A person could also be a corporation or an LLC. All right, the rest of this says that a bona fide agent of a carrier is not a broker. So a dispatcher for a carrier doesn't count. Now, here's an important segment that I want to do. And then I think I'm going to, I'm not sure if I'm going to give you a break here or, well, we'll see where we're at. I'm about to run out of time here on the module, so we'll see where we're at. All right, 371.3. Records to be kept by brokers. This is important for you to understand. A broker must keep a record of each of its transactions and keep the records for how long? 3 years, all right? Circle that, underline it, highlight it, do something with it. 3 years. Now, the next part is very interesting, especially if you are currently a motor carrier working with brokers. Each party to a broker transaction has the right to review the record of the transaction applicable to them. For example, motor carriers accepting transportation shipments from brokers have the right to review any, keyword, of the required documents retained by brokers. Each record must show the following things. Note, number 4, the amount of compensation received by the broker. Light bulb. Folks, when you're a carrier, you know what the broker's paying you, but what you don't know is what the shipper is paying the broker, and in essence, what his percentage is, right? What his profit margin is. Wouldn't it be nice to know? Guess what? All you got to do is ask. Now, there's a political consideration that we have to keep in mind about asking, because there can be ramifications. We'll talk about that in just a moment. But before we do, I just kind of want to suggest that this is a very strange regulation, if you think about it. It's kind of almost like anti-capitalist. What I mean by that is, let's take it to a different industry and kind of see how peculiar this really is. If I were going to go back into my old department store that I used to work in, which is JCPenney, right? Yeah, sales department. What if I go over to the jewelry sales department? And what if I looked in the case and I saw a really nice piece of jewelry that I wanted to buy my girlfriend, right? And I see an ankle bracelet. It's got a little diamond on it. I say to the jewelry clerk, I say, "Sir, how much is that?" And you say, "Well, that's $300. Show me the tag. And in fact, it says $300. I say, "Whoa, $300. I love my girlfriend and all, but gee, I don't know if I want to spend that much. Can you kind of cut me some slack here? Maybe do something for me?" And the jewelry salesman says, "Well, I'll tell you what. I'm not supposed to tell you this, and I don't think my boss is around, but if you buy it tomorrow morning, we're having a sale all day tomorrow. So what I'll do is I'll put a little tag on it. It says, 'Hold for Mr. Lamb.' We'll put it aside now. Nobody else can buy it over the next 24 hours. You come back and you see me tomorrow. Here's my card. Ask for me. I'm Bill. And in that case, what I'll do is I'll sell it to you at 1/3 off. So instead of paying $300, you'll only have to pay $200. I'll save you $100. How's that sound?" I say, "That sounds great. Thank you so much for letting me know. I really appreciate that. Really want to get that for my girlfriend, and I'll see you tomorrow. Oh, but by the way, before I leave, let me just ask you one more question. How much did JCPenney pay for that item?" Now, you want to have some fun? On your way home before 9 o'clock when the mall's closed, you go stop at JCPenney. You go to the jewelry department. You do that as a sociological experiment. You go up to the jewelry clerk and you ask that question. His or her jaw will drop. They'll probably start to drool a little bit. And they'll basically say, humana. I don't know what we paid for it. I mean, my boss may know, but I don't think we can tell you what we paid for it. They will be so shocked that you asked. Does anybody ever ask that question? No. They just make that decision based on the price. Here's the retail price, and here's the sale price. Oh, I'm saving $100. Yeah, that's a good deal. Might be a good deal, but what if it only cost them $20? Then it's not such a good deal after all, is it? See how subjectively you can reevaluate and think one way and then all of a sudden go the opposite way? That's what happens here. Now, in this instance, there's a legal right to find out the information. If you ask as the carrier, what does the broker have to do? Tell you. They got to show it to you. Yeah. Now there's ways to play games with this, and if I say fax it to me, they may say, well, it doesn't say I have to fax it to you. It says I have to hold it open for inspection. So there you are in Wyoming, and I'm in New York City. You come on down to my office anytime, Monday through Friday, and I'll be happy to show it to you. Right? Making obstacles in the way. That's not the spirit of the regulation. It says you got to show it. Right? So in essence, you would want to fax it. Okay. Now, we need to talk about power dynamics here. What I mean by that is you all have to have a very clear understanding about the relationships among these three parties. Shipper on my left hand, broker in the middle, and of course carrier on the right. Now, when I have my hands out equally here, is that an accurate reflection of the true power dynamics here? Or do certain people have more power over other people? Right? Maybe that's more accurate. In fact, whenever I point to my left and I look at my carrier, or I should say my shipper, am I looking equal, eye to eye? Am I looking down, or am I looking up? My shipper is up above me, right? In fact, do I cause any problems for my shipper? Do I make any waves? No. Every time I deal with my shipper, I get down on my knees and I say, "Thank you, almighty shipper, for this load. May I please have another?" I pay homage, right? It's the way it is. not as easy to get up as it used to be. So hold on a second here. Okay, there we go. Okay, I'm getting old. All right, now, if I look for my carrier, where's my carrier? Is he above me? Equal to me? Or is he below me? He's low man on the totem pole, right? On the food chain, right, there's sharks, and then there's man, right? And then there's horses and cows and pigs and all those animals. I don't know if you eat horses or not, but you know what I'm saying. And then at the very bottom is these microscopic little creatures called amoeba and paramecium. There are these little worms and slugs, right? That's our carrier, the slug. Now, do I mean any disrespect? No, I'm trying to be funny here, right? You know that. But the point is that they're lower than us on the food chain, okay? Low man on the totem pole. Now, what's interesting about this is that this regulation brings into the equation a fourth player. We have shipper, we have broker, we have carrier. Who's the fourth one? The government. It's the United States DOT that made this regulation. And whereas the power structure is normally we're up here and the carrier is down there, with respect to this one issue, it elevates the carrier up to our level. If they ask, we have to give it. If we don't, they can go to Big Brother. Big Brother will come and slam us on the head with a fine for not complying with the regulation. Right? Without this regulation, what would happen? This guy comes to us and says, hey, James, we'll call him Bill too. Hey, James, you know that load we did last week, last Tuesday? Well, pursuant to Section 371.3, we'd like to see your business record. So why don't you go ahead and fax us over the invoice that you sent to the shipper? If you got that request from this little slug down here, what would you normally do? You'd look over at him, you'd look down at him, and you'd say, wait a minute, let me get this straight. Are you talking to me over there, right? That's what you'd say. How dare you? Who do you think you are? Don't you know where your true place in life is? You work for me. You're not going to be bossing me around, but this is the law. Now, we got to have a way to deal with this. So, in the event that we get this request, we have to have a strategy. So here's this guy, Bill. We did this load with him last Tuesday, and now he calls us up and he asks us for the document. Here's how it would play out. And you know, it doesn't matter what type of broker you are, whether you're a good broker or a bad broker or even an evil broker, you're going to follow the same strategy for different reasons. Evil broker, why does the evil broker not want the carrier to get a copy of his bill to the shipper? He doesn't want the carrier to know that he ripped him off, right? Oh yeah, I made 60% of the load, right? If you make 60% of the load as a broker, there's no way you can rationalize that you didn't rip somebody off, okay? Some people do. Some people actually do make 60% of the load. I'll show you how they do it in a minute. All right, I'm not going to suggest that you do it, but I'll show you how it's done, all right? Now, if you're a good broker, you're not hiding anything, but the problem is the difference in perspective. Remember how I said that the broker sees the world one way and the carrier sees the world another way? Well, now we're going to talk about that. Now, here's what I would do. Bill asks for the document. We have him on speakerphone here. So I'll say something like this. Yeah, I remember that load, Bill, that we did last Tuesday with you. You want the shipper invoice, huh? Okay. Not a problem, Bill. In fact, you know what I'm going to do, Bill? I'm going to stop everything that I'm doing. I'm going to drop it all just because you called, and I'm going to walk all the way. In fact, no, I'll run, Bill. I'm going to run all the way over here to my file cabinet. Yes, sir, Mr. Bill. I'm going to get you that document, sir, and I'm going to pull it out from my file cabinet. I'm going to bend down. Do I like to bend down? I got a bad back. I don't like to bend down. Do I like to bend down for slugs? Oh, no. But for you, Bill, yes, sir, I'm going to do it. I'm going to get that document all the way over here to my fax machine now, and I'm going to load it up. Here we go. What's your fax number, Bill? Oh, okay. Here we go. I'm going to put the fax number in. Here we go. I'm going to press send, Bill. You ready? 1, 2, and oh, but by the way, Bill, before I press send, you do realize what happens next, right? What happens next? Once I press send, nothing happens next. Nothing as in no more loads. You know why? Because apparently we have a problem that you don't want to really talk about. Why don't you man up, Bill, and tell me what's up? Is there a problem? You know, we've been doing this business, what, 6 months, 12 months? I use you every Tuesday, give you freight every week. And now all of a sudden, out of thin air, out of the blue, you pull out section 371.3 of the regulations. Why don't you tell me what's going on? What's the matter, Bill? Don't you trust me? Now, should you trust any broker? But in this instance, we are the broker, right? Now, of course, you're putting him on the defensive. The next thing that's going to happen is he's going to say, well, you know, I didn't mean to offend you. I just thought I'd get the document because it says I have the right to the document. Yeah, well, I'm feeling pretty offended, Bill. In fact, I'm starting to really get upset. And, you know, I don't know if I'm ever going to get over it. In fact, kind of reminds me of my marriage and how I wound up having to get divorced. I think maybe you and I ought to go our separate ways as well. Be okay. I'll be all right. You'll be all right. You'll go and find another broker, and I'll just find another carrier. Ooh, I'm really getting upset. Now, he's going to come back and he's going, no, now wait a minute. I didn't mean to upset you. I didn't mean to offend you. No. Is there something I can do here maybe to kind of fix this a little bit? I don't know, Bill. I don't know really. I'm really upset. I don't know. Of course, Bill, I can think of one thing. You know what we could do? I know. You know how we can make this better? What if we take the document out of the fax machine and we walk back over here to the file cabinet and we go ahead and we refile it and we pretend that this little phone conversation that we just had, Bill, never happened. Yes, sir, Mr. Lamb. I think that might be a good idea. In fact, I'm really sorry I bothered you. And is it okay if we pick up that load next Tuesday? Yeah, Bill, you go ahead and you pick up that load. And I'm sure I won't be hearing much from you from this point forward, will I? You'll just do your job, and we'll make sure that everything goes well. You'll get paid, and that's pretty much the deal. Thank you, Mr. Lamb. Click. Now, did I break the law? Says he has the right to the document. He didn't get the document. Did I break the law? No, what I did was I reminded him his true place in life, which is down here. No. You work for me. The government can tell me I have to give you the document, but what the government can't tell me is that I have to continue to do business with you. I choose who I do business with you. You know what, Bill? I just don't like troublemakers. I don't like people who make waves. It costs me too much anxiety. I need to sleep at night. Otherwise, I got to take those Xanax pills, right? All right, so that's scenario number one. Now, scenario number two is, what if I have the document loaded in here, and he says, unbeknownst to me he was going to do this, he says, actually, James, yeah, go ahead and press send, because you know what? I'm already done with you. Now what do I have to do? Now I got to press send. But folks, if I'm going to send him the document that he's asking for, which is the invoice to the shipper, so he can calculate how much money, right, that he made and how much that I made, I'm going to send him another document. I'm going to send him the document that is the printout from the TransCore rate index that shows me what the going rate range was for a truck. And that gets us now to the conversation of the two different perspectives. You see, when Bill is going through this whole thing trying to get the invoice, what he wants to know